Thank you all for coming. Of course, I'm Chrissy Lott, and today I'm going to talk about legal and ethical issues in education. The first thing that we're going to talk about today is religion in public schools. Now, the First Amendment to the Constitution addresses the personal freedoms of students and school personnel involving speech, press, assembly, and religion. And there's two separate clauses in the First Amendment that actually addresses religion. Now, the first one, it actually prohibits the state from passing laws that aid a religion or show preference for one religion over another. So that would apply to us as educators. We can't impose one religion over another with students. But the Free Exercise Clause actually gives individual freedoms for students. So they have those freedoms, and we'll talk more about that later on. So when we're talking about school-sponsored prayer, we have a couple of court cases that we're going to talk about. The first one, Jones versus Clear Creek Independent School District, says that non-school-sponsored, student-initiated prayer at graduation ceremonies is permissible. And of course, student-initiated is very important right here. It does not violate the First Amendment regarding separation of church and state. And then the other court case that we're going to talk about is Engel versus Vitale, where it says non-denominational prayer was recited by a class at the beginning of the school day, and students were allowed to be excused. So we would think that that would be okay. But the state and the high court ruled that this was a violation of a First Amendment. So of course, going back to the school initiating it. So what does this mean for us? School-sponsored prayer is illegal based on the Establishment Clause. We can't impose one religion over another. But voluntary school-led prayer is permissible under the Exercise Clause of the First Amendment. So regarding Bible reading, the first case that we'll talk about is Murray versus Curlett. So in 1963, the United States Supreme Court ruled that daily Bible reading was a breach of neutrality. The courts ruled that school prayer and Bible reading violated the Establishment Clause of the First Amendment. And then Abington School District versus Shemp. In 1963, the United States Supreme Court ruled that school-sponsored Bible reading in public schools is unconstitutional, but this is very important. The courts did specify that the use of Bible for historical, literary, ethical, or philosophical purposes was permittable. So we go back to what does this mean for us? It can be used, the Bible can be used for instructional or educational purposes. But just school Bible reading as a whole would violate the Establishment Clause. Now the next thing we're going to talk about is freedom of expression for students. Students are entitled to First Amendment rights as long as the actions do not create material and substantial disruption in the educational process. Now, Tinker versus Des Moines Independent Community School District. Let's talk about this case. So in 1969, the United States Supreme Court ruled that students possess the same constitutional rights as adults. So in this case, during the Vietnam War, students wore armbands in protest of a government policy that was initiated in Vietnam, and they tried to prohibit this from happening. But based on the First Amendment, freedom of expression, the courts actually ruled in favor of the students. But then in a contradicting case, Blackwell versus Issaquena in 1966, students were denied being able to wear freedom buttons to school. So the principal had told them, it had caused a disruption in the school, and the principal had asked them because of that to remove the buttons, and they didn't, and therefore the courts did support the principal in suspending those who did not stop wearing the buttons. So the difference in these two cases was that there was no evidence of disruption in the Tinker case, whereas in the Blackwell case there was evidence. So decisions that are made regarding freedom of expression is kind of on a case-by-case basis. Now, regarding protests and demonstrations, protests and demonstrations are part of free speech. and students are entitled under their First Amendment rights. So some of the things that can be prohibited though would be any material and substantial disruption, indecent or offensive speech, of course, a violation of school rules, destruction of school property, and a disregard of authority. So regarding school-sponsored and non-school-sponsored newspapers, Hazelwood School District versus Kohlmeyer, this is an interesting case. They ruled in favor of a principal for removing some material from a school newspaper because students had highlighted 3 pregnant teenagers in the school paper. So that was a violation of their rights, and they gave details regarding a student's parents' divorce in the school newspaper. So they actually supported, in this case, they supported the principal in removing that material. And then in Bystrom versus Fridley High School Independent School, this was a case involving non-school sponsored papers, and they supported a school in prohibiting material that was vulgar and indecent. So legally, for us, legally defensible editorial policies should be in place. So schools, if these policies are in place of what is acceptable and what is not, those are the things that we need to refer to. Restrictions should not be enforced unless there's evidence of defamation or disruption. So some impermissible material would include anything that's vulgar, obscene, libelous, or mocking others based on race, sex, origin, color, or religion. Now, regarding search and seizure, the Fourth Amendment, of course, protects us against unreasonable search or seizure, and it protects students from being searched without cause. Some reasonable searches could include, if you have reasonable suspicion, reliable information from a reliable source, not just gossip or third-hand information. You can't just search because you have a gut feeling that something is going on. And here's a court case, AH versus State Court, did not meet reasonable suspicion since the teacher only had a gut feeling. So they ruled in favor of the student. So educators need to know that reasonable suspicion must be demonstrated in order to conduct searches. So searches can include, but are not limited to, text messages, social media, so student phones, lockers, student vehicles, student desks, student book bags, purses, computer bags, etc. But of course, the most important thing to remember is that you have to have some kind of evidence, evidence of suspicion. So the next thing we're going to talk about is students with disabilities. The Students with Disabilities Act of 1975 says that the Individuals with Disabilities embraces the notion that children with disabilities would be placed, when appropriate, in educational settings that offer the least amount of restrictions, which is called the least restrictive environment. Irving Independent School District versus Tatro determined that students be placed in educational settings to the maximum extent possible with non-disabled peers. So that least restrictive environment, when it is written in IEPs, just means that whenever possible, that student needs to be placed with their gen ed peers. So what is an individual education plan? An IEP is a plan that is developed to ensure that a child who has been identified as having a disability, who attended, received specialized instruction and related services. So related services can include speech, occupational therapy, physical therapy, other services related to their education. And so, of course, an IEP must be followed word by word. You must implement accommodations according to that IEP, and anyone who works with that child is an active member of the IEP team. So concerning liability and student records, so you've probably heard of FERPA. FERPA stands for the Family Educational Rights and Privacy Act. It's a federal law that allows parents the right to have access to their children's educational records. They can have their records amended if they need to, and they have child turns 18 or enters a post-secondary institution, the right transfers from the parent to the child. So a release of information must be signed by the parents. So anytime records are transferred to another school, it has to be signed by the parent before that personally identifiable information is released. And that's for children under the age of 18. So be careful what you share with other educators or staff. A good rule of thumb is in a text or email, anything written, use student initials or last names instead of writing full names. Be careful what you share at the ball field. And I mean, really, number 3, only share what is necessary. So someone who directly works with that children, or with that child, they would be, you can share with that person something that directly relates to their education. So now we'll get down to the Alabama Educator Code of Ethics. So what is the Alabama Educator Code of Ethics? It is designed to protect the health, safety, and welfare of students and educators. It defines actions that are considered unethical in nature for what is, which actions need to be addressed. So I will send you the link to the Alabama Code of Ethics. It's very interesting. Anytime you have a question as far as is this inappropriate or is this appropriate for a teacher to do, this kind of addresses anything that might be questionable. Are educators required to report a breach of a code of ethics that they see another teacher doing? Yes, they're required to report a breach as soon as possible, but no later than 60 days. Possible disciplinary actions can be anywhere from a warning or a reprimand, suspension, or a loss of your teacher certificate or leadership certificate. So the standards, and I have a copy also that I'll give you before you leave. The standards include professional conduct, trustworthiness, unlawful acts, of course, teacher-student relationship, alcohol, drug, and tobacco use, public funds and property, remunerative conduct, which that's receiving funds and for favors or anything that conflicts with your job and receiving funds from a vendor illegally, maintenance of confidentiality, and abandonment of contract. So due process. So we are protected under the 14th Amendment. Of course, the due process is a course of legal proceedings established to ensure that the state respects all legal rights and protection of our privacy. Due process balances the power and protects the individual. So the due process clause of the 14th Amendment, like its counterpart in the 5th Amendment, provides that no state may deprive any person of life, liberty, or property without due process. So this applies to public school districts and provides the minimum requirements for procedures that each public school must satisfy when dismissing a teacher who has attained tenure. So a court case that actually addresses this is Cleveland Board of Education versus Loudoun. It provided that a tenured teacher must be given oral or written notice of the dismissal and the charges against him or her. So also for a tenured teacher, an explanation of the evidence obtained by the employer has to be given, and they have to be given a fair and meaningful hearing. So thank you all for joining me today.